Is it morning in America again, or are we on track to reach the darkest of nights in American constitutional history? Who knows, but it is fun to speculate. Welcome one and all to our second episode of the 2024 winter-spring season of the Constitution of American Life with the Friends of Publius. We have received a few comments from listeners wondering why we don't have more equal geographic representation here on the band of fops and amongst us constitutional commentators. Some have said that having two Midwesterners and two Californians provide a somewhat weak perspective and a confusing cuisine. First off, I need to remind our viewers that I reside in Kern County, California, whose primary founding fathers were from the South. And most influential cultural expression is identified as Okie. Remember, Bakersfield is just Oklahoma that got lost in California. So I believe it is fair to say that we do have the South covered. Now, trying to cover New England has been more difficult because, well, you know, those from New England aren't known for their ability to play in the sandbox with others. However, I am so excited to announce that we have struck it rich and found our fifth Beatle from the land of the Puritans, the land of the Red Sox, baked beans, and Aerosmith. We welcome to the team Peter Gunn. Professor Gunn is clearly a Renaissance man. He is a graduate from Dartmouth College, go Keggy the Keg, and Harvard University, was an educator for nearly 4 decades, now is a small fruit, vegetable, and maple sugar farmer who also dabbles in the summer vacation business and volunteers for organizations that address food insecurity and environmental concerns. Welcome, Peter Gunn. It's nice to have you here.
Thanks for having me, Dave.
You bet. So we have one major question for right now. We'll have others as we continue on this year, but one major question for you, since you could end up becoming the deciding vote in many of our squabbles. Would you consider yourself more of a Pink fan or a Meatloaf fan?
Oh, man.
Or do you like pink meatloaf?
Yeah, stay away from the pink meatloaf. I once was more of a Meatloaf fan. I am now more of a Pink fan.
I think you have that in common with Professor Williams there. Yeah. So you have an
ally,
Mike.
I do want to give you props for the intro mentioning Aerosmith, because I need to correct you. They are not a Boston band. They are a New London, New Hampshire, the town that I reside in, band. That's where Tommy Hamilton's sister babysat me, and I used to do a children's dance where Stephen Tallarico, not Steven Tyler, but Stephen Tallarico's father played the saxophone, piano, and just about anything else you could imagine. So I like the Aerosmith reference. I'm definitely in on Aerosmith.
Right, and again, as most of us in the rest of the country, we don't identify you guys as singular states. You're just New England. All right, so Aerosmith represents New England there. So in our first episode with our new bandmate, we are going to be addressing issues surrounding the Eighth Amendment and the federal system of justice that we have here in the good old USA. One of the most challenging issues facing any government is the challenge of crime and punishment. As James Madison said, justice is the end of government. It is the end of civil society. So let's begin our discussion, as we tend to do, and go back to the beginning, a place where our beloved Professor Moore is most comfortable. So, Tim, what factors contributed to the framers' belief in the need for an Eighth Amendment?
Well, I think the major factor that contributed to the need for an Eighth Amendment is 6 out of 13 state constitutions that were written in the Revolutionary time. 6 out of 13 had statements that prohibited cruel and unusual. It's interesting, they all use the word ought. Excessive bail, ought not. Cruel and unusual ought not. So that's interesting, because Madison will eventually switch that to shall not. So the point is, in the state constitutions, nearly half of them have almost word for word what we have in our Bill of Rights. It also is the need comes from the ratification debates when 5 of the 9 states that sent along recommendatory amendments, 5 had a statement that was very similarly worded to the eventual 8th Amendment. So the need was because, I guess the short answer is it's kind of always been there. Now, if you're an anti-federalist, the need is like there's a great tirade by Patrick Henry, as he was wont to do, in the Virginia Ratification Convention. And he was going on and on and on and on about it. There's, first of all, that there's no Bill of Rights, but then he, in a couple sections of his speeches, he really hones in on, if there's no Bill of Rights, the national government will do all kinds of cruel and unusual punishment. And of course, he hyperbolizes, I don't know if that's a word, but he hyperbolizes that the national government will do, because everybody knows that this is a part of British history. It's in the English Bill of Rights. Blackstone in the 1760s has some really interesting things to say, and pretty heady. You talk about exceptionalism. He was very prone to contrast the British form of punishment to the continental forms of punishment. Continental was just, and honestly, the continental governments were pretty barbaric at times. Now, that's not to say that the British weren't either, but a little bit less so. And I think even Leonard Levy's pointed this out in some of his books, that the British weren't nearly as harsh.
Well, this is going to show my naivete here, but under the British colonial system, was there an excessive use of punishment in the colonies?
Sure.
That would, I mean, is there an excessive, executions or torture that I'm not aware of?
Well, excessive. I mean, here's another thing about that's very fascinating. From the very get-go, and even Jefferson mentions this because he was involved in reforming the Virginia penal codes in the 1770s. And he proposes, and he picks up on this trend throughout interpreting cruel and unusual, that there always was an element of different times as we go down the road of history. Maybe what was deemed to be okay a century ago, we now know is not. So there's always, it's very interesting to me that, I mean, later on, we'll probably get to, this evolving standard of decency thing that seems to come up. But that was around even at the founding period and goes back into British history. They always kind of update, that was really cruel and barbaric. Can't do that anymore. Now that means we can chop your head off, but we're not going to draw and quarter you, chop your head off, and then feed your liver to the birds. So there's been this evolving standard of decency principle throughout the British system. So that was quite interesting to me that that was there. Now I think one of the two best instances that really kind of get to this evolving standard of decency principle that was around early in Pennsylvania and New Hampshire's state constitution. In fact, New Hampshire state constitution has probably the longest explanation of what they're meaning by cruel and unusual. And you can see both in the New Hampshire as well as the early Pennsylvania Bill of Rights in the colonial times that there's this idea of proportionality and also this idea of punishment being reform, not extinction. But there's all kinds of punishments around in the colonial era. It's just this evolving standard of decency that I've seen there allows them to jettison certain forms of punishment they deem to be, of the past and barbaric.
Well, I'm curious, does the standard vary geographically in the colonies?
Yes.
I mean, we know that today that standard or just value of the death penalty varies geographically. In the 17th, 18th century, is that true of the original colonies?
Yep. I mean, there are in fact, Massachusetts body of liberties, there's all kinds of stuff. It's a great document for all kinds of purposes. But if you want to see, I mean, there were things in the Massachusetts body of liberties that were violations of church law or heresy. So there was capital punishment. Now, very rarely, as we go down the history of colonial Massachusetts, was they used early. We famously have the witch trials, but there are differences from colony to colony in terms of harshness. But every one of them has this notion that we're going to evolve in our understanding of what's they use the word barbaric quite a bit, and we've got to get rid of the barbarism. We're still going to have punishments. I'm not painting a rosier picture than what happened, but it is interesting to me that they constantly revisit what's barbaric.
So, Professor Kavanaugh, I think one of the key antecedents, and I may be wrong, that's why I'm asking you, comes from the Enlightenment, comes from Italian Enlightenment thinker Cesar Beccaria, who wrote eloquently about his opposition to capital punishment. What were his arguments, and do you think those arguments are applicable in the 21st century?
Yeah, I want to jump back for just a second, though, for the students. I think for that, the question you asked Tim, I would go back to the English Bill of Rights. I know Tim mentioned that, but that language there is the same language that you'll find in the Virginia Declaration of Rights, which a young James Madison is going to work on with Mason, right? So I think there's a link, absolutely a link there as well. So, a young Madison working on the Virginia Declaration of Rights, he's already had it in his grill early on in '76. So when he turns around a few years, 13 years later, 12 years later, and writes a Bill of Rights, that's going to be in there. So I think there's a strong link to that too. But again, what was cruel and unusual then was, drawing and quartering and breaking you on the rack and disemboweling you and cutting off your ears. And that's was neither cruel nor unusual because that's how they rolled. So especially if you were a Catholic and not a Protestant. So Protestants were okay. Catholics could be in trouble. But back to the question about Beccaria. He wrote something, it was published in 1764 called On Crimes and Punishments. And he was absolutely inspired by Montesquieu's Spirit of the Laws. I think that's from where he gets his inspiration. And he is, his viewpoint, I think today, what we would call it progressive, maybe. I think that would be a safe thing to say. And he was going on and on about how bad this is to do this to people merely for revenge. And I found a quote. I found a quote from him. I want to share with you guys. So I'll put this in the resources. The death penalty cannot be useful because of the example of barbarity it gives men. It seems to be absurd that the laws, which are an expression of the public will, which detest and punish homicide, should themselves commit it, and that to deter citizens from murders, they order a public one. So, the idea that it serves as a deterrence, that was really I think that was the only thing he said that was acceptable, because now you have turned the government into the murderer. And are his arguments applicable today? Oh, well, of course they are. And back to what Tim talked about with that, the standard of decency, and that evolving standard of decency that we see in the case Weems is at the root of the question when the court, says, yeah, this guy can't. You're going to lock this guy up for 10 to 20 years and put him in chains and hard labor for forging a document. That seems a little excessive. So his arguments absolutely are applicable to this day, right? That he torture, secret accusations, the death penalty. He suggested the pretrial detention. I mean, we talk about cash bail to this day, right? And he would be opposed to that type of system. So I would say that his writings would be considered very progressive. And are they applicable today? Yeah, because the idea that the death penalty is a deterrent, we know that numbers don't bear that out.
Well, and I guess the reason I asked that, Well, first off, is Beccaria representative, and this is to really anybody who wants to chime in, is Beccaria representative of general Enlightenment thinking in the 18th century, or is he an outlier to a certain degree, given the commonality of the death penalty on the continent and in England at the time? So I'm wondering if if
I
he
don't.
does represent universal Enlightenment thinking, or
No,
if he's an outlier.
he's not an outlier. I mean, Tim mentioned Jefferson. Jefferson called it the last melancholy resource. Dr. Benjamin Rush in Philadelphia was very much opposed to it. Has some very strong language about it. Tim mentioned the Philadelphia Constitution of 1786, so prior to the National Constitution, limited the death penalty to certain categories. So I think that, and you see colonial governments that will morph into state governments will pull back from some of the things that were happening in what we would think in England. If you've ever seen for students, if you've ever seen the movie, oh gosh, what's the one with Mel Gibson? He has extensions. He plays a Scottish guy.
Braveheart.
Braveheart.
Oh,
Freedom!
yeah, Braveheart.
Yeah.
Yeah. Well, when he's getting disemboweled and he's on the rack at the end, and they're torturing him to get him to confess. They had protections in England at that time against cruel and unusual punishment. But again,
Right.
Breaking somebody on the rack, disemboweling them, drawing and quartering them, that's how they roll. But the colonists then that will morph into the early state governments, they're going to say that is too harsh. We need to take a step back from that.
Well, help
but
me out.
Blackstone, even Montesquieu acknowledged that there's some things deserve the death penalty. So the way I tend to look at it, I think Beccaria is not typical, which is really remarkable, I think, because some of these other folks in that time period now they are interested in reducing the number of charges that can get you the death penalty. But there's still some acknowledgement that it's valid in certain instances.
Right. I just want to make sure I'm on target here. Beccaria was against the use of the death penalty in all cases, right?
I don't think it was against. I don't think it was 100%.
Okay.
I think there's an idea that there's he was a big on his big thing, and I think it was like in chapter 6 of his writing is on proportion between crimes and punishment.
Yeah.
So if you look at his writings, and students, I'll put a link in our resources to a quick reference for him. But it was more about the proportionality of the punishment. And he says therefore there ought to be a fixed proportion between crimes and punishment. So I don't know that he was, David, I'm not sure that he's 100% opposed to the death penalty.
Yeah, because that's where I guess I would draw the distinction. I would agree that in the second half of the 18th century, you have, I guess, some progressive movements, we might call them, to narrow the use of it versus the absolute eradication of that method of punishment. And again, that debate is still ongoing today. My second thing is, I guess, and I think you've probably helped me, Chris, on this. Beccaria, this was not a belief established in religious morality. With
I don't think so.
Beccaria, right?
I don't think so, because I think he will on some of the actions of the church that the church has taken as well during the Inquisition. So his is not grounded in what we would call faith. We said more so in the equal application of the law, if that makes sense. Yeah.
So, Professor Williams, if I understand correctly, most of the world has either abolished the death penalty completely or allowed just a very limited use. However, most of these nations over the last 100 years had allowed the death penalty at some point in their history. To the best of your ability and knowledge as a comparativist, what factors, in your opinion, motivated most of these nations to move away from capital punishment?
Yeah, I think there are some kind of global reasons, and I think then each country is going to have its own particular reasons. But I think the global ones are, to me, what are the most persuasive. And I see the death penalty, and if we're talking about specifically death penalty or other acts of punishment, it's ultimately an expression of state power, right? And one of the main attributes of a state is a monopoly over coercion. It's the ability to enforce its will if it wants to. And we've had these institutions around since the mid 1600s, but it's only been since the mid 20th century where there's really been global rules and standards that have kind of tried to limit what states can do as best they can given the sovereignty of states. So over the last 100 years, there has just been a global change in opinion over the use of something like the death penalty. And you can see that slowly happening, beginning with the UN Declaration of Rights, where they declare a right to life and everyone has a right to dignity. They don't say that states cannot have the death penalty, but in 1966, in the International Covenant on Culture and Rights and Politics, they do pretty much say that states should not arbitrarily take the life of someone else. So these standards are all there, and they're happening at a time when also many countries are transitioning from colonialism to their own sovereign states. So many states that transition to democracy do not adopt the death penalty, just in general, right? So you have this kind of universal kind of change in norms about what we think is acceptable for states to do. You have world bodies that can pronounce on that. Now we can debate whether they actually have any teeth, but they can pronounce things. So you have different expectations for states. Now, combined with that, you think of a place like Western Europe and all the way to Eastern Europe. Right now in Europe, there are just two countries that have the death penalty, Belarus and Russia. I think Latvia, based on my records, Latvia is the last country to get rid of the death penalty in Europe. It did so in 2012. And the reason is quite simple for a country like Latvia. It's part of now, like to become part of the European Union, you have to get rid of the death penalty. So when you have these sort of now not only international norms, but you're telling states, if you want to get into our club, right, you have to get rid of it. That's going to be a powerful factor as well. And then I'll bring up two other things that I think are a little more specific. One, I didn't think about this. I came across an article that we'll put into the resources. Some scholars argue that depending on the type of political system you have makes a difference. So systems that are more consensus modeled, so not winner take all. So think of parliamentarian systems, systems where you have to have coalition governments. They find that they're much more likely to decide to get rid of the death penalty versus a presidential system or a winner take all system where you basically would have two parties and one party might be pro, one party might be against. And then finally, countries like South Africa that come out of like centuries of brutal oppression where the death penalty was used as a way to keep people in line, consciously sort of say, we need to get rid of our colonial past by not allowing the death penalty to be in place. And what's really, really interesting with most of these cases, definitely South Africa, even England, United Kingdom in 1965, when they get rid of the death penalty, this is going against the public opinion within the countries. Like most South Africans wanted the death penalty to still be in force, but the elites at the time during the transition decided against it. So there is this maybe sort of tension between kind of public, universal, international norms and then the norms within sovereign states.
So, Professor Gunn, the United States has kind of had a minor schizophrenic relationship with capital punishment. In 1972, the court found capital punishment unconstitutional, and then just 4 years later, they then established that under certain guidelines, the capital punishment is constitutional. What factors, to your knowledge, contributed to that quick turnaround of the court saying unconstitutional and then 4 years later constitutional?
So when I'm working with the students, I always encourage them to think in threes. And my answer to this question comes down to the 3 M's. You can have a change in the membership of the court. The court can change its mind, or the mood of the country can change. But before I explain that, I want to go back to what Chris and Tim were speaking of before, and again, use Massachusetts as an example, since I'm here on behalf of New England. Nothing I enjoy more in class than disabusing my students of some of the great fictions of American history. And one of the greatest, of course, is that the Puritans who founded Massachusetts were huge believers in religious freedom. One of the most important death penalty cases of the 17th century involved Quakers. Everybody hears about Anne Hutchinson getting banished to Rhode Island. Fewer folks know the story of Mary Dyer, who, as a Quaker, kept coming back. And her co-conspirators were executed before she was. I think they first had their ears cut off and then holes burned through their tongues, and then they were executed. With Mary Dyer, it took 3 trips, but ultimately she was executed. So that law was repealed. It had been passed by a 13-12 vote in the Massachusetts General Court at the time. And the king said, no, you're not doing that anymore. But Massachusetts famously continued to execute people. In 1806, Dominic Daly and James Halligan, 2 Irish Americans who happened to be the Irish Americans closest to a crime, were falsely accused, convicted, and executed. And most folks know the cases of Sacco and Vanzetti. So Massachusetts has a long history of treating outsiders very harshly in terms of punishment. And, again, I think it sort of forces students to reconsider what we believe to be the roots or the foundation of our identity as a colony and then as a state. In the case of the Furman and the Gregg decisions, Furman v. Georgia and Gregg v. Georgia from 72 to 76, I just want to put it in context so that folks know that the court has changed its mind before. We're familiar with Brown versus Board of Education overturning Plessy. That took 60 years. So that wasn't a membership change or a change in the mind of the members. That was a mood of the country and some great legal work done by Mr. Houston and Mr. Marshall with the NAACP. The next example that comes up is also famous for Gideon's trumpet, right? The right to counsel. In the court took about 20 years to overturn Betts v. Brady, which I think was an early 40s decision, and in the early 60s said, nope, you get the right to counsel. Important to note that at the time that Clarence Earl Gideon was incarcerated in Florida, there were somewhere in the neighborhood of 4,500 inmates in the Florida penitentiary system who'd been convicted without an attorney. And that was in the time when I was alive. It's amazing to think that. The fastest turnaround we know was Minersville v. Gobitis and West Virginia v. Barnett. And I think that one illustrates a change in the mood of the country and a really persuasive dissent. In fact, I encourage people to go read the opinions in both of those cases because it's great. There's nothing, secondary sources are terrific, but to the students who are out there, taking a read into some of these opinions can be really, really helpful. Now, the most recent one that's controversial is Roe and Dobbs. And I think that's the one where we see kind of all 3 things at work. Although I think to a lesser degree is the mood of the country changing. But certainly we've had a change in the membership of the court. And some members of the court appear to have changed their mind from when they sat before the Senate Judiciary Committee and when they became justices. So we get around to Furman and Gregg. The only change on the court is Douglas goes and John Paul Stevens comes in. The cases are really technical, and I think for students they need to get into understanding that the 8th Amendment is involved, but also the 14th Amendment, not just as a matter of incorporation, but also just the principle of due process itself. And there are even references in some of the opinions to the Equal Protection Clause, though it doesn't often get cited. I think it's kind of an under-examined dimension of the cases that certainly in the Furman decision, one of the big issues was all of the evidence that was presented. And this is why Brown is a useful reference point, because they used a lot of sociological evidence in Brown to convince the court that separate couldn't possibly be equal. And they used a lot of evidence in Furman to suggest that the way the courts were allowing states to handle the application of the death penalty was having a disparate impact.
Peter, can I just check in? Is it accurate to say that the dissent, or I guess it would be, I'm trying to figure this out. I know that Thurgood Marshall spends much of his career trying to get the court to address race and the criminal justice system and execution. But it's my understanding as well as the court pretty much, as a majority voice, has never really addressed the issue of race, and did not in Furman or Gregg. Am I wrong on that?
Well, I think Douglas talks about it in his opinion in Furman, and he's the one who brings up the element of a denial of equal protection. I do think you're correct. I agree with you that racial impact was part of why Marshall and Brennan both said the Eighth Amendment prohibits the death penalty, period, full stop, don't get into the details. It was a 5-4 decision. Furman was a 5-4 decision, and the four dissenters really seized upon the emphasis on procedure. And what happened over the course of 4 years in Georgia and many other states is they really went through the laundry list that the court laid out of things that you had to do. For example, separating the process of determining guilt or innocence from the process of assigning the punishment. What's called a bifurcated system was one of the things that the court objected to, the absence of it in Furman. And so by the time you get to Gregg, Georgia has said, okay, we'll do this in 2 parts. First, we'll have a trial about whether or not the person's guilty. Then we'll have a separate proceeding about what the appropriate punishment is. So I think that students need to understand that it was a 5-4 decision. One of the justices, most famously, Blackmun, will switch, right? Isn't it Blackmun who says, "I will no longer tinker with the machinery of death" in the 94? I think it's the Collins v. Collins case. So that's an example of the justice changing his mind. Too late for Mr. Gregg, but I think that what we see in that change there is a little bit of a change in the composition of the court, but more, there was enough room left open in the initial decision in Furman so that states could address the due process, equal protection concerns, and all of that under the umbrella of cruel and unusual, enough so that you could get, the Gregg decision, which allowed states to go back to applying the death penalty.
So, Chris, one scholar commented that in some ways, the Eighth Amendment cruel and unusual clause is shrouded in mystery. Do you agree with that, or do you think the courts have provided much more clarity in the last 25 years or so? And I want to use an example here that I just became aware of. Out here in California, I think you're aware that homelessness is just off the rails. The Ninth Circuit has agreed to look at, or is it Supreme Court? I can't remember. It's the Ninth Circuit, I know, has agreed to look at a case in California and in Oregon here. But what intrigued me is that one of the original decision, which I think is Martin versus Boise, they use the Eighth Amendment to say that localities cannot, arrest and jail homeless people, even though they might be violating some local statute here about access to public or use of public property like sidewalks, parks, things like that. That's a violation of the Eighth Amendment, which to me seems an extreme application of that. So that's kind of where I'm at, is where do they get cruel and unusual in the homeless situation there? But is the problem that the language is again so vague that trying to come up with a standard, not only a nationwide standard, but even maybe a statewide standard is very difficult?
Well, I think it goes back to Justice Berger, and was it Trop? I remember that name right? Trop.
Trop v. Dulles, yeah.
Is it Trope?
Yep.
Okay, Trope v. Dulles.
I
Yeah,
think.
it's Trope v. Dulles. It was at like 50, and help me out, mid 50s,
Yep.
1954. I'm going to pull that at somewhere 52, something like that, where they're changing evolving standard of decency. So I don't know that it's shrouded in mystery. I don't know that I would agree with that assessment because so much of it depends on your constitutional interpretation. I think how we have people that call themselves originalists, right? So when you want to go back and see what was being done in 1791, well, we were doing these things, but I guess one thing they wouldn't have had in 1791, they wouldn't have had the electric chair. So that definitely would have been unusual, right? In 1790, in 1791. So I don't know that it's shrouded in mystery. I think so much depends on the constitutional interpretation. I think you have to take into account one of Peter's 3 M's, and that's the mood of the country. I think the people have moved away from the idea of that. I was just reading an essay by Thurgood Marshall, and he talked about the ideas of when the death penalty is appropriate, and even what he said when we've used the death penalty, it's almost shocking now in a modern sense. So I don't know that it's shrouded in mystery. I think it's just a question of where we are as a society, and also you also think about too science being what it is, and where we have more physical evidence, which seems to be probably better than maybe even eyewitness accounts, because we know eyewitness accounts are not all that great. We also understand that juries, given their choice between life sentence without parole and the death penalty, they're going to take the life sentence without parole. So I don't think it's shrouded in mystery. I think it's just a question of how we decide to apply it.
Well, who's the we? Can it be a popular? Through popular?
Well, as it stands right now, and what Peter was just talking about after the decision, Greg v. George, is the states, right? And then, of course, people are going to challenge the 3-drug cocktail. They're going to challenge the new methods that states are going to have to come up with, because we see that changing. Right? We see drug companies no longer making those. We see doctors not participating in these things. So but it's going to be up to the people in the state, because people still want the death penalty, I think. I don't know. I don't have numbers at my fingertips on what the popular opinion is towards the death penalty now.
I disagree with the scholar shrouded in mystery. I guess to me, it's if you want an absolute definition of what cruel and unusual is in all times, in all places, throughout, everywhere on the timeline, well, then you could come to that conclusion. It's shrouded in mystery because there's been an evolving standard of decency. It seems to me that the whole question about cruel and unusual is also a story about things over a time period being jettisoned because they're deemed to be barbaric. They were okay at one time, but this evolving standard of decency is centuries. That principle is there. So if you want an absolute fixed answer, you might be prone to say it's shrouded in mystery. Well, I guess I don't buy that.
Professor Williams.
Yeah, I just wanted to add, I'm also thinking that for most Americans, thinking about how to punish people is not like on the top of our minds. And I think we tend to maybe reflexively think in terms of retribution, and that sorts of punishment are okay, I guess. I think the homelessness example is a good one, David. I mean, we'll put the Martin v. Boise case in the notes. The Supreme Court is going to hear the case. It's called Grants Pass. And what the Ninth Circuit decided in 2018 is they said, cities cannot either give people tickets or put them in jail for sleeping on the sidewalk when they have nowhere else to go. So they told cities, you have to go up to people and you have to say, look, we have a shelter available. If you don't want to take the shelter, we're going to cite you or arrest you. But like in San Diego, we have about 100 beds every night in downtown San Diego, and we have, at last count, 2,500 people sleeping unsheltered. And the argument for the Eighth Amendment was that it's cruel and unusual to punish someone for their status. So if your status is that you're experiencing homelessness, it'd be equally cruel and unusual to punish someone for being an alcoholic. Like if someone takes a drink and is drunk in public, it's one thing. But if someone has a disease, right, to punish someone for their status, this is what the Ninth Circuit said. The Supreme Court is most definitely going to change this, and they're gonna somehow either distinguish or overrule Martin, and they're going to make it much easier for cities to do this. And I get back to something Chris said, and then I'll be quiet on this. Just as there's no evidence that the death penalty is a deterrent for those to commit crimes, there is no evidence that giving people experiencing homelessness tickets or arresting them makes people less homeless. It's really, if there's anything that is cruel, is for someone that has nowhere else to be, to on top of that, to give them a ticket or to throw them in jail. I think it's really.
How about giving them a ride to the city limits or the county line or something like that? Don't roll your eyes, Peter, because I don't know, where you live. But
I'm not rolling. I'm not rolling my eyes.
wait.
I'm thinking that you're spot on with that, because look at the way in order to make a political point, look at the way governors are exporting people around the country to ostensibly manage a crisis that they face, but I think we could all agree are also trying to change the public mood by about whether you want to call these folks undocumented workers or illegal immigrants or whatever it is. So I think I think that Mike's point is one I agree with, and I would add that question of status is what makes, to move away from the death penalty again, sentencing a teenager to life in prison without parole. And somehow, I think, again, to go to the mood of the country piece, I think there's a lot of folks who feel relief that, okay, we're not executing this person. But it strikes me that the status of someone as a teenager, when there's all the scientific evidence out there about the mental development of a 17-year-old, even if they've committed a horrific crime, you could argue that that's a punishment based on their status. That's essentially punishing them for being incredibly immature. Now, hundreds of thousands of incredibly immature people don't commit those crimes. And I suppose that would be the distinction that people would draw and say, okay, well, look at all of this person's classmates who didn't shoot up their school and do incredible harm and inflict pain on people. But still, I think the issue of status is, and the evolution of scientific knowledge and awareness. And this goes back to Chris's point about, I suppose if we use Socrates, they've always had drug cocktails that they knew would work to end someone's life, but they sure as heck didn't have, the electric chair. So I guess I'm getting a little bit ahead, but I think the question of status really matters to what is cruel.
So I am curious, Professor Moore, based on what you said, does the evolving standard, can it go both ways?
Well, that and that's where I think Montesquieu. I was looking into this past week. Montesquieu has this interesting couple of lines in his section on punishments, that the barbaric nature of some punishments actually, whether they're legitimate or not, or whether the person deserved it or not, is one thing. He points out that this coarsens and creates a barbarism amongst the people. I mean, just the mere fact. I mean, he's questioning this whole thing. How coarse and barbaric will government's policies make innocent people if they're okay with all of this? So I think Montesquieu has some interesting insights about just how cruel or barbaric you can be as a culture, and I think some of the founders were also not quite real excited about turning all the policy over to the demos. So So I think it probably can cut both ways. Now, whether the laws do or not, that's
I
a
mean,
different
I
question.
look at this word decency, and I look at how crass we have become.
Yeah,
And I
right.
think that in most of this country, that if you put it up to a popular vote, as far as method, all right, just beyond whether or not we have a capital punishment, but the method of punishment, I think you put it up to popular vote, we would go backwards.
And we'd
People would
sell
like it.
tickets. We'd sell tickets in pay-per-view.
Which is I've always been an advocate of. If we're going to allow the state to kill people, let's sell tickets, and because if it's going to be a deterrent, people actually have to see, and they have to have some kind of experience with it for it to be a deterrent, if that's going to be an argument for it. But I am wondering, so theoretically, because generally when we talk about evolving standards of decency, it's this notion of trying to be more humane, all right, in our execution. But if it's evolving and society is evolving, I guess, backwards, if we want to say that, would that standard then therefore apply if the people want to come up with more draconian and entertaining ways of imprisoning or executing people? There, kind of something to think about. Peter, you kind of already did address this, but what's your sense about the new court? It's not very old. It's 3 appointees by President Trump there. And as Mike said, we do have a case that's going to be looking at cruel and unusual punishment based upon the knowledge that you have. Do you get a sense that this change in personnel is going to affect and have an impact on Eighth Amendment jurisprudence?
I think so, because I think that the whole notion of the Constitution as a living document is not well received by a slim, if not a super majority of the court. And the whole idea of things evolving without people actually amending the Constitution is, just doesn't sit well with them. In the dissent in Furman, Rehnquist, this is why it's also, again, a pitch to students. This is why it's good to read dissents. Rehnquist goes through an incredible discussion about judicial review, the limits of judicial review. He responds to Douglas's references to John Bingham, who was the author of the 14th Amendment. And there's some discussion about whether this was a privileges and immunities issue or a due process issue. But there's a fascinating discussion about how limited, and I would defer to Tim on this, how limited the conversation was in Congress about the meaning of the Eighth Amendment. I do know that one representative, whose name escapes me at the moment, expressed the concern that this shouldn't deny people in the future, society in the future, doing something because people think of it as cruel. And it's sort of a complex question. I think Megan Ryan, and we can put this into the resources, has written a great piece just this past December about the death of the evolving standards of decency. And I guess to sort of put a final point on my contribution to this question, we're having this conversation on King's holiday, and King's letter to Birmingham jail talks about just and unjust laws. And I think a useful activity for students of the question is, whatever you may think of the Eighth Amendment, how does the death penalty square up today and historically with the metrics that Dr. King laid out for what defines a just law? I think that could be a really productive learning activity for students and give some real depth to their answers to this kind of question.
So, Mike, given the nature of our criminal justice system, and what I mean by that, the federal nature, there are those out there that would love to have national sentencing guidelines, not just in capital punishment, but in all felonies. But that seems to me to be very contrary to our federal system there. So what is your thought about sentencing guidelines for felony and capital crimes there? Do you think that our Constitution would allow uniform national standards that all states have to follow?
I don't think so. I think not only our understanding, but the way the court has ruled on questions of federalism. I mean, this is clearly states have a lot of autonomy in terms of deciding issues of public order and crime and punishment. So now, would I like to see more national standards? Maybe, but I don't know how to. This is where the F word federalism, I think, really constrains what you can do. I do think, I mean, what students should be thinking about is like some countervailing sort of like values, right? So our federal system allows states to decide on a lot of these issues, which is really good in terms of local autonomy. But it also is going to lead to a lot of inconsistency. And we can ask ourselves whether it's fair that if you commit the same crime with the same underlying facts in one state, that you could have a much different punishment than if you committed in a different state. I think that's something that students should be willing to think about. I think given our federal system, that's the way, that's kind of what we are stuck with. And
Mike,
yeah.
sorry, Mike, can I just, doesn't that point that you've just made go back to the argument that the court made in Furman, is that within states, the diversity of the treatment of various people when it came to the death penalty made it a violation of due process. I mean, this is a really tough nut for students to struggle with, because we've got due process and federalism whack right into each other. Because, I mean, what do you think of that?
Yeah, I mean, I think it's where it's one thing to tell, I guess, states that there are some national, federal due process, procedural due process limits to what they can do. I mean, I think if we're going to have a balance, right, I don't think we can't allow states to do whatever they want outside the constraints of the federal constitution at all. So I think that that's the balance, but I do think that that's what you're pointing at in terms of that's going to be the inherent tension in making some of these choices.
Well, I'm wondering, help me out. When we had the whole question of mandatory minimums for drug cases, was that just a federal law and only applied to federal cases, or were mandatory minimums something that the federal government imposed on state governments with drug laws? Does anybody know?
I thought states.
You saw this.
Go ahead.
Yeah. Well, I think we were going to say the same thing, Peter. I think you saw states enacting those as well. So, and if you talk to judges, they're probably not very happy with the idea of mandatory minimums or the 3 strikes and you're outlaws or other things where these are going to tie their hands in terms of sentencing. So the idea that punishments must fit the crime, which I think is at the heart of the Eighth Amendment. One of the core principles in the Eighth Amendment is the punishment must fit the crime. And so I think if you talk to people that were in the process of, they serve as sentencing people, especially judges, they don't like the idea of mandatory minimums or 3 strikes and you're out. But you would see those enacted at the state level as well as the federal level.
Yeah, proportionality is a principle that, I mean, you can go back thousands of years in jurisprudence, and proportionality is at the heart of trying to figure out what is reasonable punishment. So proportionality is always around, and in federalism, proportionality may vary from place to place.
Tim, wasn't that the essence of the court's opinion in the Timms decision when they incorporated the excessive fines part of the Eighth Amendment? Remember, this was the drug dealer where, in addition to the sentencing, they took the guy's luxury car.
Yeah.
And I thought the court basically was sort of saying this is excessive, right?
You're asking something, first of all, it's con law, strike 1, strike 2 after 1800. So I'm on my back heels here, Peter.
Yeah, you're right, Peter. That's the case out of Indiana, because the guy was driving a Range Rover. And
right.
So actually the fine was a few $1,000, but the Range Rover was like 60 or 70 grand. It's like, oh, hold on. This is a little too much. And so we finally, I think that's the most recent incorporation case that we've had, isn't it?
Yes.
The Timms case out of Indiana.
Yeah, I think it is. And I think his argument was that if you take the vehicle, it would prevent me from being able to work to pay the fine. And the court, whether that was persuasive or not, I thought it was interesting because that was a case where, in Sentinel, Samuel Bryan says that the genius of common law is its resistance to innovation. And I wonder how much the current court today subscribes to that idea that we had it right at the time that the document was written, and we ought not innovate beyond what the people have explicitly told us. So I guess that's a backdoor way to come back to your question to me, Dave.
Well, Mike, just clarification for me, because again, I'm the slow learner here. This federalism and criminal justice issue and uniform laws, doesn't the 14th Amendment due process clause allow the federal government to create uniform sentencing? Since it seems to me all sentencing for felony cases would fall, under the 14th Amendment due process clause. So can you clarify for me? Or you or Peter or anybody?
I think it would be more like minimum wage. I think that they could establish certain basic parameters and still respect the right of states to pursue what makes sense in their locality. So I think that's more where they would go. And I know that's economics and it doesn't necessarily translate to criminal justice, but as a model of how you navigate between the two, I think that they might use that as their escape hatch, for lack of a better term.
Yeah, I honestly, I'm not sure, David. So I'm not going to comment. I'm not sure.
Well, I like the ceilings and floors argument there. So we've come to the end of our time here on Unit 5, Question 1 on the 8th Amendment. And as is our tradition, we ask our scholars to provide some final thoughts, recommendations for students and teachers as they prepare for the national finals there. So Professor Kavanaugh?
Oh gosh. Well, I'm sitting here, I'm listening to this excellent discussion. I keep thinking of, Peter alluded to a couple of cases a bit ago when he's talking about the 3 M's, and he's talking about Gobitis to West Virginia v. Barnett. And certainly Justice Jackson's opinion in West Virginia is just, obviously, it's poetry. It really is just, it's so powerful. But I think about how we take that opinion and apply it to the death penalty. When the people in the state say, we want the death penalty. And yet you're going to say, well, dropping this cyanide tablet in this bucket is going to take at least 10 minutes. Or this 3-drug cocktail that you're going to give me doesn't always work. Or you're going to shoot electricity through my body till I'm dead. You're going to hang me from the, I'm trying to think about how, the passions of the majority play out in death penalty versus, say, the flag salute cases from the 1940s. And I don't know, I don't have the answer for that, but that's just kind of rolling around in this parking lot I call a brain. I think too, for the students that, for this question, this is a tough question, but, there's a lot written and there's a lot of research on this. This is a tough thing because we're talking about capital punishment, and this I'm going to share personally. I was one time I was a supporter of the death penalty. I'm no longer in support of the death penalty. Much like Justice Marshall, if he would get the phone call, he would take it no matter the time of day or night to issue a stay, because we execute poor people. We execute people of color more so than we do other people. I think the idea that we've had overzealous prosecutors, we've had overzealous justice systems, if you will. And I don't like the idea of, if we're going to execute a person, the state is going to execute a person, that we all have our hands on the plunger. And I don't like the idea of the number of innocent people that we've sent to be executed. So I struggle with that personally, and I no longer I'm a supporter of the death penalty. So I'm just sharing that with students, my personal journey in trying to figure this out. This is a tough topic. We are talking about people's lives, but we're also talking about the laws and within our states and our country. So good luck.
Professor Moore.
Yeah, I think this is a fantastic question, because I think students, and we've alluded to this, but I think it bears repeating. Students, you're going to have to deal with this. It's a squishy. The evolving standard of decency for people that want things in black, white, and consistency, black and white. This is a tough question because there has been an evolution in how we perceive barbarism. And to David's point earlier, can we recede in embrace barbarism in terms of so it's a great question, but it's I think Chris has said this before. There's no right or wrongs on this. There's only good arguments and less good arguments. So I think this is a great question for you to really kind of sort through all the nuances of an evolving principle in the Eighth Amendment.
So it's squishy, but it's not a squishy mystery.
I don't believe it is, because there's no mystery, and the fact is it's going to be a contested issue throughout history.
Professor Williams.
Yeah, I agree with all that, and I think that I think our little our brief discussion of homelessness and the debates around cruel and unusual punishment for those experiencing homelessness, I would encourage you to be, when you're thinking about societal attitudes about what's cruel and unusual, to just think about that case again. We'll put it in the notes so you can have the case and maybe access to some of the briefs that have already been sent up to the Supreme Court, because this is something for a lot of, depending on where you're at, this is an issue that maybe is much more front and center than the death penalty for a lot of us on a daily basis in terms of what we see and experience. But along with the death penalty, Chris's point about, if you do any research at all of who is right now on death row likely to be facing this punishment, it is most likely to be people who have experienced poverty, mostly people of color. And that's what you're going to find with those experiencing homelessness as well. And I think that's a bigger issue for us to be thinking about, is this is not in the abstract. This cruel and unusual punishment that is meted out, in my research, it's meted out disproportionately in terms of one's race and economic status. So that's just something to keep in mind.
Yeah, Professor Gunn.
Yeah, I agree with what my colleagues have said, and I think this is a really tough question to answer. It invites us to do all of the great thinking that's been described. I also think we need to be aware of the role of implicit bias. It's something that we understand that we have it, and how does implicit bias work its way into juries when they're deciding punishments in a variety of cases. And I think we're all, when we're honest with ourselves, aware of the moments when we've screwed up and fallen prey to our own implicit biases. The difference is that if it works its way into a death penalty case or even a life without parole case, the consequences for the victim of that implicit bias are tremendous, and in at least one situation, you can't recover. I think I would urge the students, again, go back and read some of these opinions. It's really worth it. Some of them are poetic, and they're beautiful to read. My students used to always roll their eyes when I would talk about Fed 51 and poetry of If Men Were Angels, but it's true. And if you get good at reading it, you'll enjoy it. If you're not good at reading it, sure. But the only way you're going to get good is to work hard at practicing reading it, and you're going to discover things. I think the final example that I'll offer, and I'm bringing this back to New England and to Massachusetts, is to understand that there are some answers to some questions that are politically unpopular, but may stand the test of time. Massachusetts had a candidate secure the Democratic nomination for the presidency, Michael Dukakis. His answer on the death penalty was viewed by many people. He was asked, what would happen if someone raped and murdered his wife? I want you to imagine trying to answer that question on the spot on, sort of national television. That in of itself is in some ways pretty coarse. But he said, I don't support the death penalty. I think that I've opposed the death penalty during all of my life. I don't see any evidence that it's a deterrent. I think there are better and more effective ways to deal with violent crime. Right or wrong, he was trying, I think, to provide a just answer rather than a politically popular answer. And that's what makes this question so fascinating and so difficult, is that there are two different tracks that at least two different tracks that it proceeds along. And you're going to have to work hard to get to a deep understanding on both of them. Good
Well,
luck.
and I agree with my colleagues. This is a fascinating question. Students, you are asked to deal with societal attitudes, legal perspectives, and federalism. And, gives you kind of a wide berth and a lot of material to play around with. And I echo what Professor Williams said in the sense that I think this case coming up to the court on homelessness is a fascinating one, outside of capital punishment. Just looking at what is cruel and unusual. And it's extremely fascinating because it's really not a liberal or conservative issue, because liberal governors in the Western states have signed on and want the court to reverse the Robinson standard and Martin versus Boise here and allow states and localities much more leeway to deal with the homelessness problem there. So I'd really suggest that you look into that issue. And I did notice that Mr. Kavanaugh had one final point.
I just an asterisk, and I think it's important that when you look at the question, students, that the case that the quote is from, Weems v. U.S., is absolutely tied to American imperialism and our occupation of the Philippines post the Spanish-American War. So there we are dictating to the Philippines what their law should be. So I just want to throw that in there.
I thought we were liberators, not imperialists. And we'll end on that note, ladies and gentlemen. So in our next episode, we'll be going back to Unit 1 and talking about Federalist 10 and Republican government. Until that time, keep well and keep out of the cold. Peace, love, yogurt tacos. Bye-bye. Bye, bonds.